Welcome back to Ascend Legal 101. I'm Ramona, and today I'm joined by lawyer Dana Quantz, who has been practicing at the firm of Hutchison Ozcek Marlette since 2011. Dana practices civil litigation with specialties in personal injury, insurance, labor and employment law, construction, and human rights claims. He prides himself on delivering first-class advocacy and representation to all of his clients. He regularly appears in all levels of the British Columbia court system and has appeared before the British Columbia Human Rights Tribunal, the Workers' Compensation Appeal Tribunal, the British Columbia Labour Relations Board, and the Employment Standards Branch. He is an active member of the legal community through involvement in local, provincial, and national bar associations and trial lawyer associations. Dana grew up in Alberta, where he learned the value of a strong work ethic and teamwork while playing competitive hockey. He relocated to Victoria to attend the University of Victoria's Faculty of Law and decided to make Victoria his home with his family. Outside of the law, Dana's an avid vegan cook, is an amateur martial artist, and an intrepid explorer. Please join me in welcoming Dana Quantz. Thank you for joining me today, Dana.
My pleasure, Ramona.
And just before we get started, I just want to let you know that there's a restaurant next door to my office and people are having fun on the patio. So if there's any background noise, I just want to let you know that there's not a party in my office. It's people having fun on the patio next door.
Need safe work environments.
That's right. So also, I guess at the front end, we should also say that for the purposes of this conversation, we're going to talk specifically about COVID-19 and refusal to work or having a safe work environment during this pandemic. But a lot of what we talk about might apply and will definitely apply in different situations, and that everybody should seek out their own legal advice tailored to their own specific situation.
Yes, I agree.
So because we're going to talk about safe work environments and the WCB system and what happens if you either get COVID-19 at work or there's a potential that you could get COVID-19 at work. I'm wondering if you could just tell me, just give me a little background in the Worksafe system and how does that all work?
Sure. The workers' compensation system in British Columbia is about 100 years old, or it's over 100 years old. It's existed for the purpose of providing access to benefits without having to go through a tort claim like negligence or something else if a worker suffers injury in the course of their employment. Now in BC's history, we have long history in mining and forestry. So the idea was to allow workers to be able to claim compensation from a board or a fund that was paid into by employers. And it's developed over the years. It's developed a lot of nuance and different policies, but basically the structure is employers pay into a fund based on their payroll, and workers who are injured in the course of their employment receive various benefits out of the fund. So they can receive basically three types of benefits. They receive wage replacement benefits, healthcare benefits, and vocational retraining benefits. Wage replacement benefits can be divided into temporary or permanent wage replacement benefits, essentially. And so in terms of people who get COVID-19, COVID-19 at the outset of the pandemic was not something that was listed or considered as part of the Worksafe system. So they didn't have a specific designated disease. It's been subsequently, there's a term that's been subsequently added to the Workers' Compensation Act in about July of 2020, but I'll get there in a minute. In the workers' compensation system, there's two types of injuries. There's the physical injury, So if someone trips at work and twists their ankle, the physical injury, but that's of an specific incident. So that's viewed as a personal injury. And there's subsets of that, like mental health injuries that arise and things like that. But there's also things called occupational diseases. And occupational diseases have taken up a lot of WorkSafe's time. So like asbestos can be an occupational disease. The cancer can occasionally be an occupational disease. You can get issues like carpal tunnel can be an occupational disease. It's really defined as something that's arisen in part because of work, but it's not related to a specific incident like a trip and fall or a traumatic incident. The access to benefits, however, is the same. You still get the same type of benefits based on wage replacement, healthcare benefits, and vocational rehab. These are just different doors that people can enter in to get into the system and have access to the fund.
Thank you for that. And just because when I was reading the case law that you had provided in your blog, I found a definition that you alluded to, but it was buried in the case a little bit. And I'm wondering if you could tell me sort of what is the susceptible worker, and is this the definition that sort of arrived in the summer of 2020?
No, that's not the definition. So the susceptible worker discussion is really focused in the refusal to work scenario. So the susceptible worker focuses on someone who's refusing work because they're worried that they are extra susceptible to, in the current times, getting COVID-19. In the case I referred to, this was a 2000. I think it was a 2019 decision where Vice Chair Goodwin was discussing the case of a man who said that he was susceptible because he had a child at home who was immunocompromised, and he was worried about catching lice at work. And so he characterized himself as a susceptible worker. But he didn't claim that, he wasn't making a claim from WorkSafe that on behalf of his child, he was refusing work, refusing to attend work because he thought he was extra susceptible. The definition I referred to regarding COVID-19 is a way to get access to benefits for people who have been accepted.
I see.
So when we're talking about the susceptible worker, we're really talking about someone who views their physical or health status as being extra susceptible to catching COVID-19. So, for example, I was reading a WCAT decision that was released in January of this year about a pharmacy assistant. This pharmacy assistant can't really remember interacting with the public, anyone who was sick. She remembers one coworker who was sick, but doesn't really know if he had COVID-19. The employer said this person wasn't tested for COVID-19. Yet this pharmacy assistant, did test positive for COVID-19, and the board accepted that her work was of causative significance, which means more than a trivial impact on her having or getting COVID-19, even though they had almost no evidence of where it came from. They didn't have identity, contact tracing or anything. And the board accepted that. And there's lots of examples of this, and this was approved by WCAT.
And just for our viewers, WCAT is?
The Workers' Compensation Appeal Tribunal.
Okay, thank you.
So the WorkSafe BC is kind of the operating body That's the corporate name of the Workers' Compensation Board. And when they make decisions, they have an initial decision maker and then an internal review process. And most decisions from that internal review process can be appealed to an external appellate tribunal, where that's a final decision subject to judicial review.
Okay. And so in the case of COVID-19, a susceptible worker would be somebody like if you have asthma or a heart condition, or perhaps you've had cancer or cancer treatment or something like that.
Yeah, and so that, if we take the example of that pharmacy worker, we already have some decisions in the system saying that exposure in this industry may increase the risk, and if they're particularly susceptible, then under the refusal to work analysis, particularly with a susceptible worker, they may be able to have a justifiable argument that they had a reasonable belief in refusing to come to work.
Okay.
I haven't seen any cases that come down and look at this, so our blog is trying to explore the stuff that is available that we do have. But it's an interesting, we have cases like the board has been very, very liberal in accepting claims for compensation. So we have construction worker, we have flight attendant, we have a residential care aide, we have a pharmacy. So people who aren't necessarily out dealing, like they're frontline workers dealing with COVID, but they are essential workers. And the essential worker component has appeared to be very persuasive to a lot of people for accepting claims. We're taking it a step further, though, in talking about refusal to work. So if the board is already accepting that these people are at an increased risk, do they have a reasonable belief to refuse work? Is the question that kind of remains outstanding.
Right. So I guess, you know, when I was doing all the reading, I actually had a question. So if I know that I have respiratory illness or, you know, some pre-existing condition that would make me a susceptible worker, and I'm a frontline worker, or pardon me, an essential worker. So perhaps I work in a grocery store or a pharmacy. If I'm in a union, there's a mechanism for me to take time off work preemptively, meaning I'm going to take time off because I can't get sick. But does WorkSafe or the WCB framework have a mechanism for that if you're not in a unionized environment?
No, benefits are available to people only if they have an accepted condition. So as I described earlier, you have to be able to walk through a door of compensability before you get access to benefits. One of the main frustrations for people in this system is that they make a claim, they're injured at work, and then they have to wait while WCB is adjudicating the compensability of the claim. So people would have to either sit on EI or some other sort of federal government assistance benefit, the CERB type benefit.
Right. So then how does one receive compensation from WCB if they contract COVID-19?
Well, basically from March until July, there was no defined mechanism, but there was a method of WorkSafe accepting people who had greater exposure to COVID-19 in their workplace. It's on a case-by-case basis as an occupational disease. The basic test is whether they were at a greater risk of exposure than the general public. And that's what most of the cases look at. And they don't tend to really analyze it in very fine detail for most of the cases that I'm seeing. That may change because remember, in the administrative system, no cases are binding on any particular body. So even though one decision was made today, a similar decision doesn't have to be made tomorrow. They try. I think they try their best to be consistent, but it's not like a court of law where like facts or like law is applied in the same scenario.
Okay.
There's no stare decisis principle in this, so they try to keep it consistent, but it's not a necessary requirement in this.
So,
Essentially for an occupational disease, there's three methods of acceptance. There's whether you're listed on Schedule 1, so the disease is listed on Schedule 1 of the Workers' Compensation Act. This is provincial legislation. Whether Number two is whether the disease is accepted by the board under its own policies. And then there's the number three, which is kind of the case-by-case basis, whether the person was at increased risk of exposure. So all the cases to date that I've seen are looking at the increased risk of exposure. So when I've talked about the construction worker, this individual, for example, was working in a condo building and they were having the public come in to look at condos. There were other construction workers. The board found, in light of the provincial health officer's orders, that people stay home and not associate, and he was an essential worker, he was at greater risk of exposure. So him catching COVID-19, or at least having the symptoms of COVID-19, was sufficient for them to find and accept his claim. And that was a review division decision. The change in July was that the provincial government actually added a communicable, they define it as a communicable viral pathogen to Schedule 1. And so what needs to happen to be accepted for this is that you have a communicable viral pathogen. So COVID-19 may be one, but this could apply in the future. And this pathogen is subject to either a public health order or an emergency order, and where their risk of exposure to a source or sources of infection is significantly greater than to the public at large. So again, I'm not sure the test changes all that much, but it's probably a little bit easier because we're speaking less about causative significance and more about just risk of exposure in that instance. And if you fall under Schedule 1, you're presumed to have caught it in the course of work. So I would say after July 2020, it's easier to make a claim. But I should say that most people need to know you have 1 year to make a claim. So if you get COVID-19 and you're off of work, just file the claim, because you need to, it needs to be in within a year. You can sometimes get exceptions from the board, but yeah, I wouldn't rely on that.
right, so you'd want to file your claim sort of early on, right after diagnosis, just in case it's potentially something that, you know, a lot of people are seeing that they have prolonged illness.
Yeah, well, particularly because the benefits that are available from the federal government, at least to date, aren't there to help with impairments, for examples. And WorkSafe is designed to help people with impairments. I mean, they've been helping people who've been breathing in asbestos and get cancers in the lungs. And so there are mechanisms available to help people with breathing capacity. And I'm not going to pretend that they are necessarily the fairest or always right, but it's something that's there for people to try to access. Sometimes it works well for a person. It's a case by case sort of scenario. Sometimes it really undercompensates, but that's the nature of the system.
So in the case of, well, I suppose either of the cases that we've discussed, in any case, as a worker, I go to work and expect that my work environment is a safe place for me to be. So who's in charge? Who's responsible for creating and maintaining this safe work environment?
You're the employer, without question. WorkSafe BC has uh, set out guidelines and requirements for all employers to follow. And at least every time I talk to people that from there, they're out there looking. Um, you need to have work through safety plans. You need to have done planning as to minimize the impact of exposure. The employer needs to have safety plans posted so that they can be seen and so people know what they are and that they can be followed. Um, I've spoken to employers who have developed safety committees to constantly be reviewing things and how things are changing. There are employers who basically have completely shuttered their business. Uh, it varies with industry. There's WorkSafe BC has guides all over their website that employers can download and work through. And I'm certain that the safety officers would be happy to talk with employers. I'm happy to talk with employers to help them walk through what their obligations are. But it's the obligation is on the employer to ensure that they have a safe work environment. If they do not, then the employer is open to assessments, fines, and even being shut down by WorkSafe BC. So it can be quite serious.
Right. So if you are following your plan, then, and even if you're a little skittish, as a worker, you still have to go to work.
Yes,
Correct. I mean,
yes.
if your plan says this is the way we've created a safe work environment and we've done all the things.
Yeah, I mean, workers have certain rights under the workers' compensation regulation to refuse work, but there's a bit of a problem-solving process under that to allow workers to uh, challenge uh, challenge an employer's safety plan. So, I mean, for those who want to look it up, the regulation number is 3.12, section 3.12. But it's pretty straightforward, even though it can be a little bit legal jargon. It essentially requires the worker, if they think that they're at risk of exposure, to voice a concern about an unsafe work environment. And this protocol is put in place. It applies to all sorts of work. So if I'm a construction worker and I attend a job site and they want me to go up on scaffolding without a harness, I can say, well, no, boss. Um, I believe this is an unsafe work environment and I should have a harness. There's a Section 3.12 sets out the process that needs to be followed. And it applies equally to COVID-19. It may have broader implications because now we're looking at like office workers, we're looking at whole types of people who would not normally be considered in dangerous workspaces. The process, generally speaking, is that they need to say to their employer, I want to refuse work because this is an unsafe work environment for this reason. So, for example, people are walking around without masks and they aren't within 6 feet of each other in an enclosed space. The employer would then have to go look and investigate to see A, if it's accurate, and B, if it's following guidelines. If they determine that it's accurate, then they need to put in place uh, guidelines to follow that. If they say, no, we think that's fine, and the employee continues to refuse, um, then it escalates to another level. So the next level is that the employee picks someone. What if they're in a union? It'd be someone from their union, or if it's from a trade, then someone from a trade organization, or it can just be a fellow employee in a non-unionized workplace. They would then look at the scenario and they would determine, okay, is this a safe work environment? And if that's not, if they can't come to some resolution there, then they would bring in a board officer to look into this. So there's kind of a it's kind of a way of dispute resolution that is important for workers to follow if they're really trying to refuse work because they think it's unsafe. They need to raise it with the employer first, allow the employer to investigate. If they still aren't happy, they need a third person to come in, help decide, and then the board needs to be brought in. They can't just refuse to come to work because they're afraid of getting COVID-19. That's if, particularly if the employer has put in place a safety plan, that's not going to cut it. They're just going to be deemed to have resigned from their work.
Right. When you explain it, it seems so straightforward. But when I was reading the case, it was like, how is a worker supposed to know? Because in the cases, it sets it out. Well, the worker didn't follow step 1, step 2, step 3, step 4. And I thought, how, as a worker, how would I know that I have to refer to Section 3.12 of the Occupational Health and Safety Act?
I don't have a good answer to that, honestly. Our law assumes people know the law.
Right.
And if someone's refusing to return to work, maybe the assumption is that they would call Worksafe and they would report that. Because I often tell workers that Worksafe is not unlike police officers when it comes to policing workplace safety. So if they have a complaint about, like if I see someone breaking into a building, as a citizen, I call the police. I'm not really supposed to go and just grab the person and make my own arrest. I call the police go and do that. It's similar with WorkSafe, that if you see an unsafe work environment, you report it to the board, they come and investigate, and they come and look and determine whether it's an unsafe. Is it perfect? No, but that's who we've designated in our society to do that. So I think that's the underlying assumption, not necessarily that you know about 3.12,
Right.
but that if you're unsure and you think this is unsafe, you're going to call the board and have them send someone to come look at this. And maybe they help mediate the worker through the steps. But some of the steps probably do happen on a fairly regular basis.
Right.
Just ad hoc with neither the employee or the employer knowing that they're actually following them. But I agree, it's a little bit of a misnomer in the cases that they're really looking at strict adherence to the regulation, but that's required. I mean, the tribunal can't deviate from the regulation. That's certainly one of the rules that they have to follow.
Right. And so you're, we had spoken earlier about how things have changed from 2020 or, even in recent months. Are you noticing a difference in the way we're looking at these kinds of cases, or the way that WCB are treating these kinds of cases?
Well, from my perception, WCB has been very lenient in the level of evidence required. I'm not saying that's a bad thing. I think they will likely become a little bit stricter. Most of the cases that are floating around in the media or that we're seeing are dealing with early pandemic matters. The cases that will be arising from, say, October forward, where people have had, employers have had time to get safety plans in place. They've had time to evaluate what works and what doesn't work in work environments. I suspect that the decision-making criteria is going to be more strict. So I talked a little bit earlier about the pharmacy assistant. In that case, the employer said, well, we have a safety plan in place. We wear masks, we sanitize our hands, but in that case, the board looked at it and said, well, that's true, but she may have caught it weeks before you ever put in the safety plan. So that's one issue. The impact of what these safety plans look like and whether the board's going to tighten up some of the restrictions. I would say that they've been pretty generous in what they viewed as a risk. Essentially, any sort of increased risk beyond the general public seems to be enough to get passed. So if you are like a residential care aide or a construction worker and you're interacting with people above the general public, and the general public here is defined as those required to stay home generally because they aren't essential workers. So there's this interesting non-essential worker versus essential worker analysis that's going on. They find that's enough risk to be able to tie it, even though they don't have, there's not really any evidence that this person caught COVID in the workplace. Like they don't have any contact tracing to show it. They simply have that they're positive for COVID. And that just may be the limits of the evidence that's available. But I suspect moving forward, their requirements are going to get, the evidentiary requirements are going to get a little stricter.
Right. And is there anything that we haven't discussed that you feel is really important that we haven't touched on?
Well, I think it's important that workers know that they can refuse work, but it's evaluated on a reasonable belief. So an employee can have a belief that they may contract COVID-19 and refuse work. It's okay that they're wrong. So it's okay that they're wrong about their belief, but it needs to be one based on reason, that we can show demonstrable, reasonable basis for why they're refusing. It's kind of a mixed objective, subjective test. So we're talking about an individual's personal belief and whether they had a reasonable basis for holding it. So it's a bit of an odd legal test, but that's the one that's available. So even if I attend my work environment and I notice people aren't wearing masks and it's indoors and it's contrary to health orders, and I think I have a reasonable belief that I may get COVID-19, that would probably be sufficient. But if everyone's following the policies, it's in accordance with Worksafe policies, but I'm still worried. I still have a subjective belief that I'm worried that I may catch COVID-19, even just by attending the office or traveling on the SkyTrain or on the bus or something like that. Then you may need a little bit more to establish how that's unreasonable. So what is it about the SkyTrain? What is it about the bus? Are they not wearing masks? Simply saying, well, I shouldn't have to attend work because of the pandemic isn't going to be enough.
Right. And I really hope that you will come back and talk to me about other matters, employment matters related to the pandemic. You know, I have a million questions and I know that we can't address them all at one time. So I hope you'll come back and see me again.
Anytime, always
Yes.
Happy to talk.
Thank you so much for being with me. And I'm wondering if you could let people know where they can find you if they want to be in touch with you.
Sure. Probably the easiest way is through our website at Hutchison Oscheck Marlatt. It's hom-law.com. My email is on the website and people can just email me. That's the easiest way to get in contact with us. They can also call us by phone, 250-360-2500. And we have 3 lawyers in our office who deal with Worksafe. I would be the most senior of them. So yeah, we have enough people to be able to take calls and questions. And if we haven't heard of it, we can figure it out.
Excellent. Thank you very much. I really appreciate your time and your candor because a lot of people I think are so worried about all this stuff. It's just sort of nice to know that if it feels like a reasonable concern, then it's something that can be pursued.
Yeah, and I mean, if people have questions, then we we don't always have to come in at the adjudicative stage. People can book consults with us. We offer free consults, and if they want to get something checked, then call us, and we can, provided there's no conflicts of interest, we can talk to people and see if we can try to help them even navigate it before they're dealing with a claim that they've refused work improperly.
I forgot to mention also, actually, I really appreciate your blog a lot. I read it all the time, so I'm one of the nerdy ones who read legal blogs, and I really like yours. And so I that's how I got onto this topic, and I just want to thank you for making sure that that's all there, and it's available to the public just by going onto your website.
Yes, and we try. It doesn't say who posts but when I'm doing it, I really try to just provide information that I would want to have. So, and I'm always happy to get feedback, and it's great to hear that it's helpful.
Thank you.